Welcome to another riveting episode of the Trash Talk Business Podcast, your weekly dose of reality as you're getting into this junk removal dream. If you want to grow, you want to scale, you want to build your business, let me tell you something. You've come to the right place. Whether you're in their junk removals, home services, or general business, we're the guys that got the answers. I'm Andy. He's Casey. What are we talking about this week?
We have a great guest. His name's Dave. We're about to learn what he does and why he does it.
So Dave, just so you know, that is Casey's show prep. He's like, hey, he's got a name. Let's do the thing. I can do show prep, a little show prep. I've known Dave for another number of years. Dave is one of the many lawyers
You work with him?
I have hired. Oh yeah, I have hired through the years to make the magic happen. More specifically, Dave focuses on employment law. So how to avoid litigation, lawsuits, unemployment, all of the things that make the world go round. Dave is the guy. Dave, how are we doing today?
Just fine, Andy. Nice to see you. Nice to meet you, Casey. Yeah, I not an entrepreneur myself, though I've been a shareholder in a number of law firms over the years, but don't really consider myself an entrepreneur. But I work with a lot of entrepreneurs, small business owners, people that are trying to make their dreams into reality, grow their businesses. And they often stumble over traps in employment law that they didn't know were there. So I've got a kind of a small program that I do for new employers, give them some tips on employment traps that they should try and avoid and keep themselves out of court, keep themselves out of trouble. So I thought today maybe we'd go over some of those tips that I give new employers to help them avoid employment claims as they're growing their business.
No, I like it. So to give you an idea, our listenership for the most part are service-based home service-based businesses. A lot of them are mom and pops. You know, they are newer business, and they are newer as in, I'd say, anywhere from 12 to 36 months, and they're scaling. Now, we have some guys like Andy Barton, longtime listener, Barton Bros. Junk removal, he's got 14 years and ranging in size from, owner-operator, I'm paying a couple guys cash, to I have 30 to 40 employees. How do I code them correctly in workers' comp? Who is exempt? Who is not exempt? The other challenge, and this is something I want to dig into because I've had a couple clients through the years challenge with this, which is, hey, I put everybody on salary, and sometimes they get 30 hours and sometimes they get 50 hours, and it all kind of works itself out. Or the, hey, especially, yeah, or correct, or the, hey, I just 1099 all my guys so I don't have to pay the workers' comp. Or the, hey, I pay them a salary and I only pay them on the 1st and the 15th. So maybe they got more than 40 hours or 80 hours. I don't know, because I pay them the 1st and the 15th. So those are all that's the realm of things that here's the deal. We get an hour of your time today. Dave, I've seen Dave speak, panels and whatnot. This hour of free legal advice can save you thousands of dollars. That's it. Like this is, I know it's episode 69 and we're supposed to make jokes about, things. This is a non-joking matter. Dave is a professional. For those of you who's listening, Dave looks somewhere between like Gandalf and the guy from Harry Potter. He's basically an old man wizard that knows how to not get you sued. Who else?
The guy from the Bourne movies. He was the bad guy.
Oh, you're right. He does look like the CIA guy from the Bourne. Yes, that's even better analogy. Anyways, Dave. Yeah, he's long in the tooth, as some may say.
Well, and one of the things I'll be talking about is way employers should avoid age discrimination by remarks like that, Andy. And any of that.
See? Any of that nonsense. All right, well, let's talk about that. Let's this first segment.
Let's start off in talking about the very thing you mentioned first, and that's something that comes up particularly with new business owners when they're starting to expand their business. They need some new help, get in some new folks to help provide the services they're providing. Somebody has a friend who has done that kind of work, and so they bring him in and say, hey, I could use, help a couple days a week to cover my jobs. Like to bring you on as an independent contractor. I'll pay you as a 1099 worker. Boy, that's good for me because now I don't have to pay income withholding taxes. I don't have to deal with that whole thing. You do the taxes yourself. I don't have to report you to my workers' compensation carrier. I don't have to report you to the folks at the state who set my unemployment rating. And so it works out great for both of us. Well, this guy starts working for you, does a good job. All of a sudden he's, working 30, 40, 50 hours a week. He's been working with you for a year. You're the only company he's working for. There's a falling out, and you have to terminate his services. He's unhappy, thinks he's been wrongfully terminated, goes and talks to a lawyer, and the lawyer said, yeah, well, they can terminate your services whenever they want to, but let's talk about how you were classified and how you were paid. And all of a sudden, this fellow you brought on as an independent contractor is looking a lot like a regular employee that should have been, number one, given overtime for any hours he worked in excess of 40 hours a week. Number two, should have had tax withholding done. Number three, should have been reported to the state for your unemployment rating. So the plaintiff's attorney he talks to says, well, how much overtime did you work over this year that you were working there? And the guy says, well, after the first few weeks, I was working 5-10 hours of overtime every week. And he says, well, did the employer keep track of your hours? No, he doesn't. The employer didn't pay any attention. He just paid me, the regular weekly amount we agreed on. So all of a sudden you're looking as an employer at a claim for overtime for, 50 weeks of overtime at 5 to 10 hours. That can result in double damages for that amount and for attorney's fees for the attorney bringing the claim. That's because you've misclassified this individual as an independent contractor when they should have been classified from the outset as an employee in all likelihood. In order to, and there's different tests that are applied to determine if a person providing services is an independent contractor. Depends upon the agency looking at it, or the type of claim, but there are some commonalities. So in order to justify a classification as an individual as an independent contractor, generally that individual has to maintain a separate business with an office and recurring liabilities for their own operations, such as insurance, costs for their own computer network, that type of thing. They have to make their services available to others. So if you've got somebody that's working exclusively for you and is economically dependent upon you as a business owner, he's looking like an employee. In order to be an independent contractor, the individual has to have a real opportunity for profit and loss, and can't just be paid no matter how the work turns out. They have to, in some services and some situations, be required to redo work at their own cost if there is a problem with the work. So generally, an independent contractor is going to have to provide their own tools. They have to be paid on a basis other than time invested. So if they're paid on an hourly basis, that's a clear indication of an employee-employer relationship. They shouldn't receive any employee-type benefits like vacation time, paid vacation, health insurance benefits. And there should be no permanent relationship with the employer, because the more that this individual continues working for the same employer over a period of time and providing core services for that employer, the more they look like a W-2 employee who is entitled to overtime for the hours that they have worked. And one of the ways on the claims for unpaid overtime that employers get into real trouble on these claims is that they never kept track of that individual's hours and have nothing to rebut the individual's claims when they come in and say, hey, I worked, 5-10 hours a week. Here's a computer printout, by the way, that I made up showing all these hours. And the employer has nothing to dispute that with. So that's a problem. So that's one way that right from the outset, some new business owners get into trouble in using independent contractors, classifying service providers as independent contractors when they really should be classified as employees subject to overtime regulations and a variety of other regulations.
So I wanted to say this. I learned this. I learned a lot during COVID, actually, about the differences between employees and how you classify them. But the one thing that I always saw was it was hard for me to hire a 1099 because I supplied the tools and equipment and I supplied the schedule, and I didn't want someone else to just have their own schedule. Just like I never did ask anybody to bring their own tools. I supplied everything. So in the beginning, I was actually having 1099 come in, and they would have 40 hours or less, right? I'd keep track of everything. But then I started to realize that after a certain amount of hours, I'd rather put them on W-2 because now it saves my ass as an employer. And I learned in COVID, we had a 1099, whatever. He had just started working there for 2 weeks, and his wife or someone tested positive for COVID. So then he couldn't come to work for an entire week. So I said, okay. Then the next week he said, oh, I have COVID as well. I'm going to stay home. And I told everybody, hey, if you test positive, stay home. If you don't test positive, you can come in and work if you'd like, as long as you take the proper safety procedures. But he chose not to come to work. Then his wife called, his wife called threatening to sue me because he should have been paid for these 2 weeks he was at home. Then that's when I started finding out all these different laws and employee laws and 1099 laws, W-2 laws, all this other stuff. And nothing ever happened of it. They kind of they went through a divorce and all this other stuff. But the main thing it brought to light was, man, maybe I should really double check, because I thought it was just W-2s that were in a certain category when it comes to benefits from, the government or whatever. But the 1099 thing can get you in trouble if you're not actually utilizing it per 1099 guidelines, I guess.
Yeah. And COVID certainly blew up the whole landscape there with creating a series of temporary benefit programs. So
right.
That was an unusual situation, but ongoing, there still remain these various factors that courts and regulators look at to determine whether or not someone should be treated as a W-2 employee. Where this can get really expensive is if you have someone that you're treating as an independent contractor, they get hurt on the job, and you didn't have them covered under your workers' compensation policy. Now they've got a lot of medical bills, and they come back and say, no, I was really an employee. You're responsible for all these medical bills. Your work comp carrier may be nice and say, yeah, well, retroactively put them on and adjust your rating. But they sometimes will say, sorry, you didn't list this person. Those medical bills are now your responsibility, employer. So there's a number of ways you can get burned.
So two things I want to answer. I want to speak to this workers' comp thing with regard to 1099s, because the laws have changed now in Wisconsin. If you bring on someone as a 1099, we have to show that they have their own workers' comp. Otherwise, they do fall under our workers' comp. So I want to speak to that, because that kind of kills 7 years ago. That was one of the main reasons I brought guys in as a 1099 was to not pay the workers' comp. My workers' comp is 9.62. That's for every dollar of workers' comp, I got to pay 9 cents. So for every 100 hours of payroll, it's another $10 almost in workers' comp. That adds up. And that was one of the biggest advantages for me using either cash guys, 1099 guys, or temp labor. So the two things I want to touch on is, let's start with this one first before we get too far, is the what is that like now? I mean, what if is this true that Wisconsin, everyone has to provide their own workers' comp? You can't 1099 them. Explain this to me and our audience. And is that a federal thing or a state thing?
It's a state thing, and because the state runs the workers' comp program, even though it's funded with federal funds to some extent.
Okay, because I also know Tennessee is the same way, and I know that because I have a client in Tennessee, and yeah, okay, so it's a state thing that's slowly rolling out for lots of people, or
Right.
potentially multiple states. Okay,
and why they have done this is to ensure that the state workers' compensation funds and the carriers are getting their income in and to pay for the injuries that do occur. And it's a requirement that yes, 1099 employee has to show that they have their own coverage. But the problem is sometimes they let it lapse after they get started. Maybe they've shown you some certification at some point, and you say, okay, they've got coverage, but if they let it lapse, they don't pay for it, you, the employer, may not be notified of that, and then you might get into the same problem down the road.
So far, Texas is not one of those states. I just looked it up. So far, they are not required. But if you are a 1099, you are also not covered under that employer's workers' compensation policy if you are a true 1099.
Yeah, and that's the way it is.
Okay, so
if a person is a true 1099 worker and providing some services, and they qualify under the test set up under the workers' compensation statute, then they will not be covered and do not have to be covered under the employer's workers' comp.
Okay, so let's speak to the second thing, the cash thing, right? Because this is how we all start, right? I'm 7 years removed, so you can't come after me no more. We all start with, hey, I got a buddy, I paid him cash, and then the other issue is they pay guys cash, right? If you're still in the same year and you've been paying them cash, and all of a sudden you're like, oh shit, business is scaling, I want to go legit. What is the best way, if we're still in the same tax year, to tie up those loose ends as you start to go more legit?
I'm going to tell you, I don't know that I'm qualified to give you the answer to that. I think a tax accountant is a better person to address that. I have not had to face that situation in the past and figure that out. So I would say that my gut sense is if you wanted to do that, you have to go back and identify the cash payments as payroll. You have to then do tax withholding on those amounts and a catch-up basis.
Or could you just put it under 1099 for the annual wage?
You can, but if they see part year 1099, part year W-2, that's kind of a red flag that maybe somebody will come in and take a closer look at that and see if the person was truly a 1099 worker in the first half of the year, for instance. But that's a question I would probably myself call one of my tax accountant buddies to help me make sure I could answer that correctly.
But from a legal perspective, because really, is it illegal to have someone that works for you for cash? Is that illegal? If they never sue you, there's no State Department that can come after you.
Pay someone in cash, but as a 1099 employer, you should still be reporting those cash payments,
the wages,
1099 forms. So if you just ignore the formalities, that's still a violation of the tax law.
That's what it always comes down to, right? It always comes down to the government needs their money.
That's right.
You know.
Well, so what I found, real quick, what I found is I would do the 1099 and I would pay them in cash. If they're part-time, I would 1099 my part-time guys, summertime. A lot of them were high school kids, looking for good summer work. I knew they were not going to get close to 40 hours. I would guarantee them maybe 20. And for the most part, it worked out. I don't know if that's the right answer, right? But it seemed like the most plausible way to do things. As far as full-time, though, a lot of our listeners have full-time help that they pay cash. And that's where I can see the big trouble is maybe, hey, I'm starting to get busy now and I want to pull these guys on W-2, but maybe they've been with you for a year or two and all of a sudden you want to go legit.
And it's also a problem because it makes it more difficult for you to utilize those expenses that you're paying the folks as legitimate business expenses on your own tax returns. If you're claiming them on your tax returns, but you haven't shown the outlay on an appropriate, 1099 basis, that can get you into trouble. But I want to go back to Andy's comment that this is about the money. The biggest driver of these misclassification claims really came from the various state unemployment funds after, say, 2008 crash, and there was a real drop in employment, and again with COVID, huge drop in employment, and the unemployment funds in every state are getting taxed and depleted, and it was largely as a result of that the states have increased their number of investigators looking into misclassification claims. There is within the Department of Workforce Development, under the unemployment group, there is a specific group of investigators that has increased now, I think, to about 11. These are professional investigators, some previously employed by the IRS, some employed by the Labor Department, and it's their job to go out and investigate claims like this. And interestingly, in talking with the guy that runs that department, he told me that one of the main sources of leads that they get is from competitors who know that their competitors are using 1099 people that should be classified as employees, and they feel that that's giving them a competitive advantage. They're doing things legit, and these other folks aren't, and they're underbidding them, and so they sick the state folks on them to do an audit, and all of a sudden you got an unemployment audit going on, and you have to redo your contribution calculations for a certain period of time, and can face some penalties in the process. Sometimes the State Department of Revenue will tag along and say, yeah, you should have been paying withholding tax on some of this. So that's one of the ways that this comes to the forefront. But I'm going to move on and talk about a situation when new employers want to do things right, and they decide they're going to hire employees at the outset. They are going to post listing, on some of the online forums where they can try and identify people. It's hard to find employees these days. Everybody knows that. But they can get in trouble if in their postings they inadvertently indicate that they have an intent or inclination to treat someone in a discriminatory manner. And this can come about because people aren't aware of all the different types of discrimination that the laws prohibit. They're generally familiar with race, age, sex, national origin, that type of thing, disability. But in Wisconsin, you've got all these extra classifications: marital status, sexual orientation, and a big one is criminal and arrest record, conviction records, discrimination. So an employer might think, well, I want people that I can trust and rely on. They're going to be dealing face to face with my customers out in their homes. I don't want anybody with a criminal record, and so they put something in their ad that you need to have a clean criminal record. Well, in Wisconsin, that's a violation of the Wisconsin Fair Employment Act.
So let me ask you a question, Dave, real quick on that. So the reason I would do that is because my business requires my guys to go into people's houses and schools, and I would draw a line, obviously. If you are a violator of certain type, felon or other, burglary, if it's SA, I wouldn't want to put you in a position to where you couldn't do the job, or also wouldn't want to put you in a position to where you're inside of a customer's house and you just got out for burglary, theft, or something. So
well, that's fair. And under Wisconsin law, you can discriminate on the basis of arrest record or conviction record if the circumstances of the crime are substantially related to the circumstances of the job. So I always tell people, be careful of your listings. Don't put anything in there that suggests a possible intent to discriminate on the basis of criminal record or arrest record, or age is another one that is easy to slip in. We're looking for recent college grads. We're looking for that energetic, young person to go get them. That would be can be seen as an intent to discriminate on the basis of age.
What about veterans? So that's a big one, especially when you're veteran owned, you're a veteran owned company, you're looking for other vets. Is that something to be mindful about? Hey, we want to hire vets.
Not necessarily, veterans, to say you're looking for veterans, I don't think suggests you're going to discriminate on anyone else on the basis of a protected classification. Non-veteran status is not a protected classification. It's not. So no, I don't see a problem.
Like veteran preferred or whatever.
Right. No, there's not a problem with that. The other thing, if you get past the posting without problems and you are doing your interviews, it's always important to ask the same questions of every interviewee that you interview for a job. So you don't create by a series of questions an implication that you have are going to discriminate against one applicant on the basis of their race or sex or national origin. So you want to ask the same questions. You want to have multiple people involved in the interviews, and avoid, a claim from someone you didn't hire that, based on what they said in the interview, it's clear to me they didn't want me because I'm Puerto Rican or Mexican or a woman.
But wait, about physical fitness ability. That's a big one for our industry.
You get into potential problems with the ADA. If someone has a physical disability, you can ask how they would manage to do a particular task that is a core function of the job. If they have some visible physical restriction, but you don't
like
want
if you're able to lift 75 pounds unassisted.
Right. If that's a part of your job description for that thing, that's a good reason to have job descriptions. So you set out those physical requirements, and yes, it's fair to say, ask someone if they can routinely lift that much weight, which is a regular requirement of this job.
What are some questions? I'll say real quick. I want to go on that vein of questions. What are some questions that sound innocent and are absolutely leading, like you in EEOC? Background. I used to be I was a hiring manager for our site at Waste Management. So I interviewed every driver, and verbatim, it was, here are the 15 questions you ask every single driver. And it's like, I watch guys walk in. Obviously, right when they walk in, I can see, and I say guys because 97% of the applicant were men, right? So it's like, I watch people walk in. And so it's like, you got a pretty good idea of, I can violate every single one of their EEOC requirements as soon as someone walks in. You can see most of things. So what are some leading questions? Like, I know you joked at the top of the program here about me joking about your wisdom. I mean, you confused it as my age joke. Anyways, like, what are some leading questions that can get people in trouble that you think are innocent? Because I've been in several, I've heard you speak before, and people ask like, well, I just ask them this, and it's like, yeah, that's a terrible question. It is so simple to do this right, and it's very. What's that? The classic
one is if you're interviewing a female applicant, and you ask if she's planning on having children.
Oh yeah,
that is problematic. That is a potential violation of the Pregnancy Discrimination Act, because that covers women who are or are intending to become pregnant, and some employers may eliminate from consideration a woman who's planning to become pregnant on the grounds that they think that this will interfere with her ability to do her job, and maybe she won't come back. So that's a clear one. You can ask And you should have something in your application about whether a person has any pending arrests or convictions. If they answer no and they have them, and you later find out about that, then you can use the fact that they lied about that on their application as a basis for termination and not anything about the conviction or arrest themselves. Pending arrests are just like convictions, and you can still discriminate against someone on the basis of a pending arrest, but only, again, if the circumstances of the crime alleged substantially relate to the nature of the job. But so if they have indicated an arrest or conviction, you can ask about the details of that in order to determine if it's substantially related or not. But if they have not brought it up and haven't answered on the application that they have it, it's probably inappropriate to ask about that. Inappropriate to ask about perceived disabilities. If you think that it looks like they have some type of problem, that maybe they could have a problem with alcoholism, it is not appropriate to ask them about their drinking habits. Alcoholism is a protected classification. And if they are an alcoholic, you still might have a duty to accommodate them depending on the circumstances of the disability and the extent that it influences their ability to do the job. But you don't want to ask a question that suggests that you perceive them to be disabled in a particular way. I mean, if they have an obvious physical deformity, come in with a cast on their arm, have a partial amputation, you can talk about how they would be able to perform the circumstances, the duties of the job with that. But you don't want to be fishing around because you think you see something in that person that you want to flesh out and find out about, because then you can be subject to a claim for perceived disability discrimination.
So one thing I always ask, and I want to, we're just, not live in the sense that people aren't listening right this second. However, I'll ask in the open forum here. One of the questions I typically ask towards the end of any interview is there anything I need to know outside of this interview that in your life that will negatively impact your ability to do this job? And there, because I'm also asking, do you have kids? Do you have, right, where daycare might be an issue, right? Because I have some guys where it's like, hey, I have to be off by 3:00 every day, right? Or, hey, I have legal appointments. I have doctor's appointments. If someone's like, hey, I have a weekly appointment, I got guys that have weekly PO appointments, right? I don't ask. I just say, you got appointments? What time do you need off? I don't know. I don't ask if it's a dental appointment, mental health, or PO. It's right. So is it fair to ask a question like, is there anything outside of work that is going to negatively impact your ability to do this job? I think is that broad enough?
I think that's a reasonable question. And,
okay.
But then, you have to be careful about where it takes you. If they start talking about their marital situation, for instance, in Wisconsin, it is, you can't discriminate on the basis of marital status. So
what? You can't discriminate if someone's single or divorced or married?
Right.
No, man.
And so if they're, talking about, well, I'm going through a divorce, and you would think, well, that's a lot of trouble. A person going through divorce is not going to be a good employee. They get out of the marriage, now they're going to be wild for a while. If you were thinking down those lines, that might be problematic. So, I can envision responses that could be considered to unearth information that you wouldn't want to follow up on.
That's if you ask a generic question like, "Hey, is there anything going on in your life that is going to negatively impact you?" and then they give you diarrhea of the mouth, right?
It's different.
Like that ain't on me. You're right. So if someone's like, "Hey, if I say, hey, I got an appointment," they're like, "Oh, I got to meet with a lawyer next week Tuesday," and I'm like, "All right, cool." And they're like, "Because my ex-wife, her, am I right?" And now, and then they go down this road, And then I don't hire him and says, like, oh, you didn't hire me because I'm going through divorce. It's like, no, I'm not hiring you because I needed you to work Tuesdays or whatever it is.
Even if you didn't specifically encourage them to talk about a subject that might fall into prohibited discrimination, if they give you the information, now they give you information about a disability that you hadn't seen.
Yeah.
They've got liver trouble, and they have to go in regularly for that. Now, all of a sudden, you know about a disability you didn't know about before. If you don't hire them, they might come back and say it was because of that disability that they decided not to hire me and hired Joe Blow instead. So if you didn't have that specific information, you wouldn't be able to be charged with that kind of a discriminatory decision. So sometimes I think by asking that open-ended question, you can learn things that could be used against you if you decide not to hire that individual.
I can understand that. It makes things problematic. So one thing I always ask for, the D-214, if they were event, right? If they served, I wanted to see it. Now, in the case where they had a dishonorable discharge, now, sometimes it'll say the chapter on why they were dishonorably discharged. Sometimes it says continued, and there's a second page. But is that something to be careful about if maybe you don't want to hire the dishonorably discharged veteran?
That's an interesting question as to whether or not their status and the basis for a dishonorable discharge falls within the specific language of the statute prohibiting discrimination on the basis of arrest or conviction record. I think it does not, just because the language requires a court decision, a criminal court decision. And I don't think that the military decision would fall within that. I have never looked at that though, but I don't think it would. There was a case where there was a civil action where a woman brought a claim for a protective injunction against an individual that he never come within 100 yards of her, and part of that was allegations that he had physically assaulted her, one thing and another, and an employer apparently learned about that and either fired the person or didn't hire them because of that. And the court said, no, that was a civil action by an individual bringing a claim for a restraining order. It wasn't a criminal arrest or conviction. Okay, so I think that the military decision might fall in that category, but I would have to look at that more closely to be sure.
Okay, so what can we discriminate against at this point? I mean, maybe here's the deal. Also, just for the record, Dave is also a Harley riding. Did you go to the 120th?
No, actually, I'm not a Harley rider. I'm a BMW rider. And
BMW. All right. I was going to say motorcycle. I jumped
around in western Wisconsin that weekend.
You're avoiding it. All right.
Like-minded riders.
Gotcha. There you go. So as much as Dave will cite cases that may or may not have happened, Dave actually, he's a cool lawyer, right? Because not all lawyers are cool. I have a team of cool lawyers. We had Dino featured on an earlier episode of the podcast. Dino's my general business, general counsel lawyer that does all the things, and then I bring Dave in, that heavy hitter for the employment thing. So I'll give you a compliment too. Also, before we get sued on this podcast, if I do mention Jobber later in the podcast, it's because they love me and I love them, and occasionally they throw some shekels my way. There is my disclaimer. Because here's the deal: I don't know if you knew this, Dave. This recently, this came out. This came out in the last year or two. That if on a podcast, is if you're financially compensated whatsoever by any company, and you mention them, you have to acknowledge that. So I have not used the word jobber. If you are so inclined, and now because I already know I have to say it and people are anticipating, now I can do the plug, which is if you are inclined to go to Jobber, go to go.jobber.com/Camel Crew Junk Removal, get Jobber, tell them your boy Andy sent you. You get like 20% off. They give me a little kickback. Everybody's happy. And if you're like some of our other listeners who have reached out to me, I will give you a personal tutorial of Jobber because I love the tool and because I want you to be highly successful. Also on that note, one of our clients, not really clients, listeners, guys reached out to me for the last 3 or 4 months, maybe 6 months. Landscaping guy finally jumped the ship, went from landscaping to junk removal, got jobber, got nice job, got his first review this weekend, 5-star review. So I want to celebrate the guys, right? I'm up to 700 some odd reviews. I want to celebrate the guys out there that are living their entrepreneurial dream, hooking themselves up with jobber and nice job, and now getting their first review. So it's the second company. He's done property maintenance for years, and now he's got a review under his junk removal name. So shout out to JK Property Management, because it's a big step to be of the employed. Dave, like he said from the top, being an entrepreneur is it's a celebrated title because most do not take this journey in life.
And I will say, Andy, that I love chatting with you and love hearing you talk, but you've only let me get through 2 of my top 10 employment tracks. So moving along, you'd asked about the people that decide to hire folks and just pay them a salary and kind of treat them as exempt from overtime. That's the second misclassification trap, because just paying someone on a salary basis does not make them exempt from overtime. They have to fall in one of the duties tests as well. Yes, they must be paid on a salary basis. Now they have to be paid at least $684 a week, or about $35,500 a year. But they also have to fall with one of the exemptions on the duties test, either an executive exemption where they're running the whole business, or managing a department within the business and supervising at least 2 or more employees and exercising regularly discretionary powers. So that's the executive exemption. The more common one is the administrative exemption. That applies to office and non-manual workers, not the production line folks, that exercise discretion with respect to matters of significance related to the management or control of the general business operations of the employer. So that's a lot of legal mumbo jumbo. What constitutes exercising discretion with respect to matters of significance? That becomes a matter of litigation in many cases. There's a professional exemption where people perform work requiring advanced knowledge in a field of science or learning customarily acquired over a long course of specialized training. So, and there are some other ones. There's some retail exemptions, but the top 3 are executive, administrative, and professional. So when an employer wants to pay someone on a salary basis, that's fine, but they might still have to pay them overtime if they don't meet one of these tests. And the employee can come back later on again and say, hey, you should have been paying me overtime because you misclassified me as an exempt employee when I wasn't. So employers, when they go down this road, really should talk to somebody who knows these tests and can help them evaluate whether someone is appropriately classified as exempt or non-exempt, to avoid the overtime claims potentially down the road. So,
and what's the best? So I know the way I've done it. I've sent you job descriptions and have you scrub them. What's the best way? Is that
that's
from
that
your
is
perspective
the
to
best
stay
way
out
to
of
have a
jail?
job description, and then have somebody like me go over it and tell you whether this would appear to meet the tests set up under the both the Wisconsin and federal laws and case law interpreting them. So that's the best way. Right. So a couple other things quickly, is because we are running out of time. There's one that often gets employers in trouble when an employee has been hurt, and the employer says, and they're off duty for a period of time, maybe an extended period of time, and the employer says, you can only come back when you're 100% healed. I don't want you back here unless you're 100% healed. That is an automatic violation of the Americans with Disabilities Act, because employers have an obligation when someone has been injured seriously enough for it to be considered a disability. The employer has an obligation to work with them to find out if there is a way that they can come back and perform the core functions of their jobs with or without a reasonable accommodation. So the employer has a duty to work with them and find out if there's any kind of accommodation that will allow them to do their job despite the injuries and the resulting restrictions they might have given those injuries. Some cases, there isn't.
Same go for illnesses too?
That can be made. The illness applies too. Illness falls within the ADA as well as just as a type of disability, illness or injury, including psychological and mental problems, which can be some of the most difficult to deal with people dealing with serious depression, anxiety. Those types of things can be very difficult to deal with, but you still have to see if there's a way to accommodate. In some cases, folks with those psychological disabilities might need, if they're in an office setting, they might need a more confined area so that they're away from the hubbub and distractions, for instance. And sometimes a reasonable accommodation is giving them their own office if one is available. But
we would just put them outside the entire day until they quit.
Well, there's that too. So
Texas heat.
There you go.
Another problem is the impulse termination when employer just says, I've been having problems with this guy, and today he did this, and that was the straw that broke the camel's back, and I fired him. And then I thought I better call you. And I said, well, okay, so that was the straw that broke the camel's back. Are all the other straws documented in the file? You have a paper trail of having warned this person that there's a rule that's being violated, that he's violated it on multiple occasions, and what the response, response will be if he continues to violate. And sometimes there is a good paper trail, sometimes there isn't. And where there isn't a good paper trail, if that individual happens to fall with in one of the protected categories by virtue of race, age, sex, national origin, etc., then they can come back and say, hey, this was a discriminatory termination. He just fired me because I'm Black, and he treated me differently than the white guy. A white guy in the same kind of job I do, had the same problems I did, had the same work record, and they didn't fire him. They gave him a warning. Me, they fired. Difference was I'm Black. So you can get into trouble if you don't think through the disciplinary actions you're taking with your employees to make sure it's evenly applied and doled out for good reason, applying rules that the employee's been made aware of through a handbook, preferably, and that you've done an investigation, you've got good indication that there was a violation, and that your policies have been applied consistently to all employees. So that's another area where people get into trouble by impulse terminations.
I have one question on that, Dave. So what would you tell the business owners, these listeners, the importance of having an employee handbook for the business owner?
I think it is important, specifically at the very minimum. All employee handbooks should have an anti-discrimination policy. We're an equal employment opportunity employer. We don't discriminate on the basis of all these different things we've been talking about. If you feel you've been discriminated against, here's what you need to do. You need to talk either to your supervisor, or if your supervisor's the one involved, you can go to an alternate up to the president of the company, the owner, and make sure that you're giving them a path to raise the issue. Because one of the defenses that employers have is somebody's been terminated to come back and said, I was harassed, I was discriminated against, and they've never brought it to anyone's attention. And that is a defense. If you didn't tell me, the business owner, about it, I didn't have the opportunity to do anything about it and try and make sure it ended and that you could work here peaceably. So for that reason alone, it's important to have an employment handbook that includes those kinds of policies. You want to also have other policies involved so that if there are violations of those policies, you can say, look, it was right here in the handbook. It says here, no stealing of company property. And we saw you walked off with, a toolbox full of our tools and came back with half a toolbox of our tools. So you want to have those policies laid out. It's good to have your vacation, paid time off policies established if you're able to have them. New employers often can't offer paid time off right away, but at the point in which they decide to do it, it's better to have it well defined in there. So I'm a believer in handbooks. I think it's worth the time to put them together and do them right. Another problem that people get into is under the Pregnancy Discrimination Act, because they don't quite understand this. The Pregnancy Discrimination Act has given birth to a number of EEOC. Got something showing up here. There we go. It prohibits discrimination against women who are, have been, or may intend to become pregnant. And it's designed to eliminate discrimination based on stereotypes and assumptions about a pregnant woman's job capabilities, even where the employer thinks they're doing right by the woman and maybe restricting her job duties because the employer thinks that a pregnant woman shouldn't be exposed to these conditions. Well, that decision is up to the woman and maybe in consultation with her doctor. It's not up to the employer. There was a big case about this, even in I think it was a battery plant, and the employer thought, well, pregnant women shouldn't be exposed to the kinds of fumes and chemicals involved in the plant, and they essentially laid her off. And she won that case and got back pay for that period of time.
Now, did she go back to work?
I don't remember if she went back to work after the child was born or not. I don't think so. I think that by that time they were in litigation over the fact that they had, put her on unpaid leave, and she was unhappy about that. But likewise, the guidance identifies lactation as a pregnancy-related medical condition. And if an employer allows employees to change their schedules or use sick leave for routine medical appointments to address non-incapacitating medical conditions, employers must also permit female employees to change their schedules or use sick leave for lactation-related issues. So you got to treat them like other people in terms of non-incapacitating injuries. And if they are temporarily unable to perform their functions of the job because of any pregnancy-related issues, you have to treat them the same as other individuals who are similarly situated, who can't perform their job duties, either by providing modified tasks, alternative assignments, leave, or fringe benefits. And there is, however, and this is something I think is important, another reason, important policy to have in your employee handbook, is that you only want to be providing light duty work to employees who are unable to perform their regular duties because of a work-related injury. So you only want to have light duty, make light duty available to people who are out on work comp leave.
So if someone gets hurt outside of work and you give them light duty.
Well, you don't want to give those people light duty. You want to limit it to the people on workers' comp leave, because if you're providing light duty to other folks and all of a sudden their disabilities don't improve to the point that they can get back to do their full duty, they can make the argument, well, you accommodated my disability for these last 2 months on this light duty job. Why can't you do it indefinitely? And that argument has been made. And the way to get around that is to limit light duty to people on work comp leave. That also then ties into this Pregnancy Discrimination Act, because if you have that kind of a policy in place that you limit light duty only to individuals on work comp leave, you then do not have to provide light duty to a woman who's incapacitated partially due to her pregnancy. And I mean, some employers might say, well, I want to provide them light duty, but oftentimes these light duty jobs are make work jobs that are just providing them income without providing real.
So are you supposed to put them on? Are you supposed to put them on FMLA?
If they qualify for FMLA, certainly yes, but FMLA only applies to employers with 50 or more employees, and only applies to employees within those employers who have worked for over 52 weeks and a certain amount of hours. So not most small employers are not subject to FMLA. Most new employers are not.
So if I'm under 50 employees, someone gets hurt outside of work, and I don't want to put them out. What am I supposed to do?
If they have available PTO, they can burn that. Beyond that, they are on unpaid leave, pending determination of their ability to return to work with or without accommodations. So it's at that point that you evaluate what a reasonable accommodation is to put them back. But typically, we do not recommend that you use light duty as an accommodation unless it is really a job that needs to be done, and they can essentially be transferred into a position that is otherwise being done by other able-bodied people.
Okay, so you don't modify their job. You give them a different job that happens to work
with their limitations, right?
And then do you put a timetable on that? So for example, if I got a guy that gets hurt outside of work, I want to clarify that, and he's not supposed to do stairs, right? Let's just say whatever, right? And I say, hey, I'm going to put you in the warehouse for a week because there's no steps involved. There's no stairs. And that's the accommodation I'm making for something that happened outside of work.
Right.
But I'm saying, hey, for 1 week, I'm going to make you a warehouse guy.
But when you
put the warehouse guy in the field or something.
Yeah. But when you do that, you have to be thinking, if I do this now as an accommodation and he never gets to the point where he can do steps, am I willing to keep him in that position indefinitely?
My warehouse guy forever. Yeah.
Yeah. Right. And if you're not willing to agree that is a long-term accommodation, then you probably shouldn't do it.
Yeah, at the end of the day, I mean, whether you're talking about hiring or even now accommodating, I know I made that joke earlier about, what can't we discriminate against? Fact of the matter is, I want to hire good people that want to work. And absolutely. I don't give a shit if you can, right? I say, if you can, stand for 8 hours, lift 75 pounds consistently and get along with everybody, you'll be fine here and show up on time and like time, place, uniform. I'm not asking for high things here. And then the flip side is if someone does get hurt outside of work, because shit happens. I had a guy that, wrecked his back snowboarding 1 year. Another guy busted up his hand working on his car. Like we always have made accommodations for guys for a couple days, with this reasonable stuff, right? Because we want our guys to continue getting paychecks. Or we had a guy who busted up his shoulder. He fell, and it's like, okay, so for the next week or two, we basically gave him a third guy in his crew so he could do more supervisory tasks and less lifting. And he's still got, he's still an hourly guy. So he was more responsible for driving and watching work get done versus lifting, sorting and not lifting heavy furniture. So it's like, we've always done that and never had a problem. And the flip side is I've gone through a workers' comp audit. I've gone through an unemployment audit. I've gone through an OSHA audit. Like, it sucks when you're doing what you think is right and then you get audited and sometimes you get hammered, or like on our unemployment audit, actually we ended up getting more money back. Same with workers' comp. We got audited a few times, got money back, but the whole auditing process sucks.
That's an imposition on your time and the energy of your staff.
Mm-hmm.
But, I think the important thing on providing some of the short-term modifications to their job duties is don't designate them as light duty jobs.
Okay.
Just the accommodation is you're temporarily modifying their job duties to accommodate their disabilities.
So like giving them a third guy in a truck, knowing that they're going to end up doing the lighter stuff we're not saying anything. We're just making a pending change.
Yeah, that's problematic if that person never gets to the point where they can do the regular duties again. And then they say, look, you accommodated me for 3 weeks by
Yeah.
putting the third guy in my truck. That's an accommodation you should do indefinitely. And then you have to prove, no, that'd be an undue hardship on the business. And that's not an argument you want to be in. So,
because I got to pay people like you to hang out with me. I don't know. I have learned, this podcast is a lot about, hey, don't do the same things I did that didn't work out for me. I have realized quick, fast, in a hurry, when I have hired lawyers to do things on the front end, it gets done a hell of a lot faster, cheaper, and I'm on the offensive. So, for example, I started up a company a few years ago, and I reached out to Dave, and because I had employees that were almost all salary, and I'm like, hey, is this right? I had a videography company, and Dave drafted up the employment offer letters that review the job descriptions, and also did the non-disclosures, non-solicitation, and the non-competes. And the work he did on the front end saved me on the back end, because when we dissolved that company and the people left, everything was hunky-dory per se, because we had our ducks in a row. And I also know on the flip side, when I first started in business and I thought lawyers were the devil, I realized that other people have lawyers and their lawyers are smarter than me not being a lawyer. So it behooves you to take the 15-minute phone call advice, or even legal letterhead. Dave has done that. Dave's done a few letters on my behalf, or written things up on my behalf, clarification of the law. And almost always the perceived problem goes away, because you're like, hey, this is the law. This isn't me arguing with you. This is someone smarter than me. And a few times Dave has told me, no, Andy, you're not right. This is what you need to do instead. And we change course of action before I say something that can get me in trouble. Hearing this is reinforcing, you can lead with great intention and still fail miserably.
Well, it's great to chat with you. I don't know if our time is running out here, but if we have any more time, I'm happy to keep chatting. We'll go as long as you can go, Dave. We put it down for an hour, and that way we get rid of guests that we don't like. No, actually, I don't know. I don't think we've ever had maybe one podcast we had that didn't go a full hour. No, we like to chat it up, because the whole goal is that our goal, and the whole reason we have this podcast, is that we can take my 14 years of knowledge, Casey's 7 years of knowledge, and hand it out for free so people can get farther faster, and spending less money on things. So if there's anything else, smarter.
Make better decisions smarter.
I'm happy to tell a war story about a case that I had that showed how complicated things can be.
Please, we like stories. Stories always drive home the point. Yes.
A client of mine ran a manufacturing entity, had a plant manager who didn't have the vision for where he wanted the company to go. So he brought in a guy to put above the plant manager, essentially. And the day he was going to transfer the plant manager to a second shift lead position, the fellow coughed and threw his back out and was out of work, and ended up being out of work for 12 weeks initially on FMLA leave. At the end of the 12 weeks, he told the employer, look, my doctor and I have now decided I need back surgery, and I need another 2 to 3 months off. The employer said, well, we really need to get a full-time person in the second shift lead position. It's hard to fill on a part-time basis, temporary basis. You've had your FMLA leave. We're going to terminate your employment at this point, but once you get your restrictions set and you're back in shape, come back and we'll see what kind of positions we have for you. So he ended up suing, claiming that the employer violated the Americans with Disabilities Act by failing to give him an additional 2 to 3 months leave as an accommodation under the act. So I, talked to the client. I said, look, we could settle this thing for a reasonable amount of money here, but if you want to litigate, I think we can win at summary judgment in the federal district court in Milwaukee. He said, we didn't do anything wrong. Yeah, let's defend this case. So we worked it up, put together a summary judgment motion, won in front of a fairly employee-friendly judge in the Eastern District. Got a good decision from him, my client's favor. Thought it was all done. Then the plaintiff appealed to the Seventh Circuit Court of Appeals in Chicago. The EEOC got involved. They did not like the position that the court had taken. They thought it should be the employer's burden to show that the additional leave would produce an undue burden on the employer. And our position was that no, somebody who needs that much leave is not even a protected employee under the ADA. So we had to argue it in front of a 3-judge panel down in Chicago. I got torn into by the chief judge who was on this panel asking me difficult questions all the way through. I thought we'd have trouble with her. Ended up getting unanimous decision from all 3 judges in my client's favor, saying, yes, the FMLA is the act that provides for leave. The ADA is to get people back to work, not to give them additional extended leave to be off work. Well, they appealed to the U.S. Supreme Court. And we had to go up to the U.S. Supreme Court and argue that, look, there's nothing to see here. This was just a decision was decided correctly. You don't even want to take the trouble to look at this one. And that was my job at that point, was to get them to deny certification of the case and not hear formal arguments on it. And we did win in that way. And they denied cert. But by this time, the client had invested a substantial amount of money, a lot more than he could have if he had settled up front. So sometimes in these cases, the business decision has to be made as to whether to resolve a claim early on or incur the legal fees that sometimes you get. Because once we got into this case, we couldn't now just say, back off and say, oh, we don't want to stay anymore. Once they appealed, you have to respond to the appeal. And once they went up to the U.S. Supreme Court, I had to become a member of the Supreme Court bar and go on and file a fancy brief with the court up there. So in any event,
I know. So when I worked for a company who had union employees, and they said any termination that costs us less than $20,000 is a good termination if it's, right. And so they would settle for up to $10,000, which at the time, if, drivers are making $100,000 a year, right, 10% of their salary. So they would offer them like 4 weeks severance, and almost every time the driver would take it. And we were able to offer up to 8 weeks severance to walk away. And all the union guys knew it. And so the union guys would drag it out, like, well, and it's like, what we're going to offer. You know how this ends. Take your 8 weeks or 6 weeks or 4 weeks, whatever it depends on how bad they fucked up, right? Because it wasn't worth the time. So even though we could be dead in the right, we had a guy that came, these were drivers, and he came in, smelled of alcohol, called the cops, had him breathalyzed that morning, had alcohol, blew over the legal limit at 4 o'clock in the morning. And still they're like, all right, we'll give you 4 weeks severance to not cut. And it was like, you could be right and still lose. So no, I like that. And again, when we're doing junk removal, it's not nearly that level. However, employees are loyal to you, right? There's a time, and you figured this out, we all have, there's a time where you go from your hobby to your little side business to, oh shit, this is actually paying my bills. And if someone comes after me, it risks me losing my house. And once you're in I have enough to lose my house, your employees aren't your friends. You can be friendly. You can, get dinner with them. At the end of the day, people are going to do what's in their best interest. So it's in your best interest to be upfront and fair with people, and also follow and know the law better than them, and certainly have lawyers that know the law better than you. So there's my definite soapbox.
I've had several cases that are save the business cases that, if you lose, the business goes away. And that's a terrible place for the business owner to be in, but and it puts a lot of stress on me as an attorney, knowing that
one employee can sink a ship of 20 employees.
Yeah.
That's how serious this is, that's how serious this is, because it's all good and fun until it's not good and fun. All right. Well, no, appreciate the story. Appreciate the insight here today, Dave. I know our listeners are going to get a lot out of it because there's a lot of things you don't know. And so it would behoove you to look in, take Dave's advice, look into your state. I'll do my top takeaways here right away. Look into your state laws when it comes to exempt versus non-exempt. Look into it with regard to whether or not 1099s have to provide their own workers' comp. And finally, ignorance is not a viable defense. Once you go get yourself an LLC and you start hiring employees, it's on you to know the laws of the land, typically at the state level and also at the federal level, so you don't give somebody within your organization the opportunity to sink the whole organization. So that's my soapbox. Dave, what was your top takeaway nuggets of wisdom for our listeners to leave with, if nothing else?
Well, I'd say the main problem that I see is the misclassification of independent contractors for new employers. I think that's what people really have to be aware of, that there are all these different tests that different agencies apply and would apply in cases for claims for overtime payment. So look into those requirements and be sure that if you're using independent contractors, you can justify that classification, because that can really get you in trouble down the road.
Casey, top takeaway.
And top takeaway, CYA, cover your ass. You're a business owner now. You have a lot more to lose than you have to gain. And in this day and age, assumptions will get you killed. It'll just kill your business or get someone hurt. So it's always better just to check with a professional legal counsel of some sort and before you make those extra decisions that maybe you're not 100% on. That's my takeaway from it, because I've learned a lot through hard lessons, as I think we all have in some point. Mm-hmm. And that shouldn't be the only way to learn, right? It's more of a, hey, I didn't know this, it was ignorance. But it didn't always have to be. You can always be proactive in learning the law, how you operate business, how you employ people. So I think it's just a phone call. I mean, get with someone who's local, an attorney who specializes in that field, and give them a call. Hey, you got a question? I'm starting a business. Can I set up a 30-minute consultation or whatever? It's always better to ask.
That's the other thing. A lot of lawyers will give you 15 minutes as an opportunity to earn business. I know Dave a few times it gave me a few minutes. And then once I got a few nuggets, I hired him on because he gave me the basic answers. Then eventually I got to a point where I needed additional support. Yeah, a lot of lawyers will give you 5 to 10 minutes. Hell, even I pulled Dave aside at networking events and asked him a question or two. So yeah, utilize the resources around you, because when you do need them, you're going to know who gave you first before asking for something in return. Lawyers, for the most part, want to be of help. And almost every lawyer I've ever met always says, call me on the front end, not on the back end. You're going to pay me a lot more on the back end. However, it's not as fun. It's more fun to get out in front of it and prevent problems than it is to fix problems. So appreciate that. Final shout outs, Casey, for those of you guys not watching or listening at home, Yeti was the official sponsor of Casey's hat. Yeti Coolers gives us no money, however, keeps our drinks cold. Jobber, the official sponsor-ish partner, friend of the show, getjobber.com. Anything? Oh, Trash Talk Business Podcast. Actually, that's the other thing. We'll plug that. Dave's an expert. He knows things. If you're an expert that knows things and you're listening to this podcast, we want to have you on. We want to introduce you to our friends so we all can know things. So whether you're an expert like Dave as a lawyer or you're an expert in junk removal, we want to have you on. So you go to the Trash Talk Business Podcast.com, apply to be a guest, and Trash Talk Business Podcast VIP page, Facebook. Casey, what am I missing?
Chuck It All Removal Services. They left us an outstanding review. They found us through Jobber. That's how they heard about us. Well, the guy's wife heard about us through Jobber, then recommended to him. And he's been in the business for 15 years, and he says he loves this show. He says it's very inspirational and uplifting. It really hits home when you speak the same language. So keep doing what you're doing, boys. Rick Dempsey with Chuck It Removal Services. Shout out.
There he goes. Shout out. See, we give shout outs to the loyal listeners. In this world, there's 3 types of people. There are creators, there's contributors, and there's consumers. We are out here creating. We want to have more people that can contribute to this mission and this cause. So we want to have you. We want your voice heard. We'll give you shout outs to the listeners and also have you on the show. So for Casey, Dave, myself, Andy Weins, it's been another amazing episode of the Trash Talk Business Podcast. We'll see you next week.